Thank you, Christopher. As you know, Christopher is absolutely brilliant, unbelievably intelligent about so many matters, but he mixes up right and left in terms of so on. So I want to welcome everybody and tell you how delighted we are to be part of hosting this conference here at Penn Law School. I want to especially thank all of you who from the West Coast that you've made it in here at 9 a.m. in the morning. And hopefully, indeed, some of the panel includes people from the West Coast who I'm sure have bleary-eyed, but I'm sure it's going to be an incredible conference. Let me just give you a 2-second personal story about why me personally, I find this entire area, and so I'm so gratified and delighted that Penn Law School could be moving so aggressively in this field. Years ago, more than I want to remember, 35 years ago, I was clerking in a day when all the courts got patenting cases and was handed a double patenting case having to do with design and utility double patenting. And all the judges looked at each other and said, we can't understand this. And of course, they handed it to me. And of course, I knew less than anybody else. So I went off and drafted an opinion. And I can assure you, I didn't know what I was doing. Because lawyers in those days just didn't know that area. Drafted it, and of course, it was circulated to everybody on the panel, and they all said it was brilliant because, of course, they didn't know what was going on. And this is now out there as a prime example of the best thinking at the time on the topic. I remember thinking immediately, something is going wrong here. And then as the economy grew, and it became absolutely clear that our legal system and the American economy is built on our understanding of technology and science, I get more and more nervous as time went on that this opinion was sitting out there for someone like me, supposedly to be the state-of-the-art thinking on the topic. And that is a long way of saying I am absolutely so delighted that at Penn we could have CTIC, which has just been extraordinary in bringing scholars at the law school, from academia, from around the university, from practice together in so many different areas in terms of conferences, workshops, scholarship, the Dekken IP clinic, which we work over with the Central University. It is an incredible array. And what it leads to is, if you look at the University of Pennsylvania, we now have launched a joint degree with the engineering school. We have so many different courses and academic opportunities for our students, for our graduates, and the profession. And this conference is typical at Penn. We're bringing together members from academia from across the country, members from private practice, from industry, from government, from all sides of the issue, really to grapple with these issues and in a very sophisticated, forward-looking way. And I want to thank everyone here for being part of this. I also have to thank, by name, all the members of CTIC, which has grown and blossomed so beautifully over the last few years. Obviously, Professor Christopher Yu, Professor Polk Wagner, chairing this panel, Professor Sham Balganash, Professor David Abrams, Professor Cindy Dahl, Professor Gideon Parjamovsky happens to be sunning himself in Israel at the moment, but I'm sure he's here virtually and certainly in spirit. In any event, you honor us by your presence here today, and I know we have here as part of this conference the leading people and thought makers in this field. So again, I apologize proactively for the weather, especially for those of you from the West Coast. We couldn't do much about it. In any event, let me turn this over to Professor Polk Wagner, who will be chairing the first panel. Let the games begin.
Great. Thanks, Mike. Thanks for the introduction, and welcome to everybody to Penn Law and to the CTIC Conference on Patent Reform. So this first panel we have here is on software patents. As most of you know, and I'm sure you're probably not in the room if you haven't sort of seen this already, much of the recent discussion about patent reform centers around issues related to software patents and whether the patent system is well equipped, for example, to deal with software patents, whether there's something special about software patents that require additional measures of reform, and so forth. The panel we've assembled today, I think, is unparalleled, perhaps in the history of academic thinking on these topics. But in any event, it's going to be, I think, a very interesting panel with a bunch of different and diverse views on software patents, their value, their role in the patent system. And the panelists are, and we're going to start with Mike Meurer, who's the Abraham and Lillian Benton Scholar and Professor of Law at the Boston University School of Law. Mike Risch, Professor of Law, Villanova University School of Law. My colleague David Abrams, who's a Professor of Law, Business, Economics, and Public Policy here at Penn. And Peter Dekken, who's one of our esteemed graduates and the founder and vice president of Intellectual Ventures. How this is going to work is we're going to give each panelist a maximum of 15 minutes, which shall be enforced ruthlessly by myself. And then after that, we will open it up for hopefully about 20 minutes or so for Q&A from the audience as well as among the panelists. So without any further delay, let's have Mike Meurer.
Well, let's delay a moment.
Okay.
Put my slides
Get
up.
the slides going.
And you will need to ruthlessly enforce the time limit.
I shall.
And I've got a clicker around here somewhere, right?
It's on the podium.
On the podium.
All right, you're on the clock.
Oh, man. Thanks, Christopher. Thanks, everyone at Penn. This is going to be a lot of fun, I hope. I am going to talk about three different failings of the patent system that have been identified as being responsible for software patent failure. I think that they all are serious problems, but I have a favored explanation that most of you know, and that's poor notice. But I want to talk about small inventive steps, functional claims, and poor notice as the sources of problems with software patents. I'm assuming, but you might not, that we have a problem with software patents, so let me talk a little bit about what the problem might be. The work that I've done with Jim Besson shows that, on average, the U.S. patent system, as you would expect, provides a subsidy for R&D by publicly traded firms who patent chemical and pharmaceutical technologies. We also find that the system, over the period from 84 up to 99 at least, imposed a tax on R&D by publicly traded American firms outside of those technology sectors. That's a big problem. And notice that's a problem we identify as existing in our patent system before anyone talked about patent trolls. The primary explanation, I believe, for the difference between these technologies is that good notice is provided in patents that cover most chemical inventions. And you can see, for example, that a chemical patent claim might have language like the Lipitor patent up there, which might give you nightmares from organic chemistry if you ever took that in college, or olanzapine right here. You can have this two-dimensional structure. That's structural information that communicates boundary information quite clearly. That's part of what makes, you know the movie Beetlejuice? I was going to say Mark's name 3 times, and I was pretty sure he was going to appear. I haven't had the chance yet, so you came 5 minutes too early. The primary explanation, as I said, was we got good notice for chemical inventions, but poor notice for most other inventions, especially software and business methods. So the alternative explanations that I hinted at in the title are inadequate enforcement of novelty and non-obviousness, or too much functional claiming. I believe there is a problem outside of software technology and also outside of chem pharma. So electronics and mechanical inventions, I think, have the same kind of notice problems that we have in software. But it's appropriate to have a panel like this focusing on software patents, since although it's hard to count them, perhaps as many as a quarter of our patents are software patents. So it makes sense when we talk about patent policy to think, what does this mean for pharma? That's an industry that depends very much on strong patents. It makes sense when we think about patent reform to think about what does this mean for software, because software patents are so pervasive. They're remarkably pervasive general purpose technology. Nothing comes close to it. When you look back at patents on steam engines, electric motors, telegraphs, telephones, there's nothing remotely comparable in our previous experience with patents to the current situation with the pervasiveness of software technology in patents that have issued. So what kinds of solutions do I see as being most helpful? Well, currently we have the good lat and many other strategies of mitigating the tax imposed by the patent system via patent troll lawsuits. The goal is to reduce the troll bargaining power to reduce the size of the tax. I think generally those kinds of reforms are desirable, but I speak about them as mitigating, not really curing the basic problem. The core problems predate troll activity, and successfully bringing our patent system back to provide subsidies across the board is going to require sustained effort and lots of reforms. I think we're in a situation right now that's comparable to the situation if you look over the 60s, 70s, 80s maybe with regard to antitrust law. We had significant reform that was guided by a greater judicial awareness of the distinction between competition and competitors. I think law professors played an important role in reorienting the thinking. The resulting changes were profound. I agree with many, if not all of those changes, but I hope that we can accomplish something similar here in the realm of patents. We need greater awareness of notice problems, and I hope that's going to save the day. So if we return to what I claim are the three basic problems, let me talk a little bit about each. As I said, I think these are all real problems. I'm not optimistic that we're going to make much progress improving the performance of the patent system by addressing inventive step. Here are three reasons why. First, people initially thought that software patents were failing because of poor examination. Poor examination meant, number one, examiners couldn't get access to the prior art that they needed. Software inventions weren't cataloged. I think we've come a long way to deal with that problem. Second, they complained about poor training on the part of examiners. I think we've improved that situation as well. And you'd expect if it was a transitional problem that the rate of litigation of software patents would be declining or at least converging to the rate of litigation for other types of patents. That's not true. There's a big gap between the frequency of litigation, and that gap has not narrowed over 15 years. So it's not a transitional problem. We're not going to solve it, I don't think, simply by looking for better examination of 102 and 103. Next solution, a bigger inventive step. KSR seemed like it was well-intentioned. It's been taken pretty seriously by the Fed Circuit, by the trial courts. But it hasn't made a dent at all on software patent litigation, and it hasn't affected the rate of patenting of software inventions either. It's just not significant enough to have much bite to help us deal with the problem. We could go further. I'm not optimistic that we will do that, so we can talk later about that, but I don't think we're going to make much progress when it comes to inventive step approaches to reform. Functional claiming. Mark, in his Wisconsin paper, talks about rigorous application of 112F combined with 112B. I think it's a great idea. I'll talk later about, I think Mark overstates how much that will do for us, but I certainly support that reform proposal. Notice failure. If you are motivated to reform the patent system because you're worried about notice failure, you would embrace Mark's proposal. Mark sees it as a proposal that will solve the functional claiming problem. I see it as a proposal that solves part of the notice failure problem. Transparency, we're talking a lot about that on Capitol Hill right now. I think that is critical. Better transparency in the patent system and better examination. Oops, that was supposed to say, oh yeah, that's right. Better examination that focuses more on 112 rather than 102 and 103. I think those are the kinds of reforms that are going to do the most for promoting better performance of software patents or patents generally. Yes?
Are you going to explain these terms?
I hope so. I hope so. I'm looking at the clock over here.
Six and a half minutes.
6.5 minutes. Inventive step. I think I've said this already. Why did I say that I think Mark is overclaiming what can be accomplished by reform with regard to functional claiming? Well, I disagree with his treatment of functional claiming because I think I see two different problems. I don't think Mark would disagree with me about this, but I see two different problems. I think maybe where we disagree is which of the two problems is more significant. So the problems with functional claiming are that it leads to overclaiming. This is a problem of dividing rents between early inventors or innovators and later innovators, and fuzzy boundaries. Overclaiming, which Mark is emphasizing more heavily, is bad in theory, and the patent law is mindful of this problem. We have a whole host of cases that use different doctrinal tools to try to deal with the problem of overclaiming. The list is here. I can't go into all of them. But my concern is that functional language, rather than functional claiming, promotes vagueness and ambiguity. And I say functional language because I think that it's hard to look at a patent claim and say, this is structural, this is functional. I think at least oftentimes there's a blend of those. And the problem is when we permit too much or relatively more functional language, that's what we should be paying attention to, trying to respond to, trying to rein in. We got an empirical challenge here to determine whether the problem is overclaiming or fuzzy boundaries. There's a little bit of evidence, I think, that's relevant in answering this question. So, for example, biotech versus chem. Chem, including pharmaceuticals, patent systems performing pretty well, not quite so well for biotech. I think a reason why is that polymers are much harder to describe structurally than small molecules. You will see when you look in claim language associated with biotech invention, a lot more language that talks about what this molecule is doing. That becomes necessary, even for plastics. When you're dealing with polymers, it's hard to say what the structure is. You inevitably bring more functional language in. Evergreen Pharma. There's a nice study by Hemphill and Sompat that says that if you look at patents on active ingredients, they're golden. They're hardly ever litigated, hardly ever infringed. They speak very clearly to the world of pharmaceutical innovators. And everyone knows to get a license or steer clear of the property rights associated with them. Much more of a problem for late-stage pharmaceutical inventions that, again, introduce functional language. Like, here is a polymer coating that causes this drug to spread through the body at a certain rate. That kind of functional language invites problems in understanding what the scope of the property right is. And it's not just software where the problem exists. Prison walls, in the Phillips case, wall hanging systems and unique concepts, lots of other kinds of technologies have functional language that creates confusion about the scope of the property rights. So let me talk in the rest of the time that I've got about what I mean by notice failure. So a lot of people have the impression that I am obsessed with fuzzy boundaries and that reducing uncertainty associated with the scope of the property rights is the goal that I'm pursuing. That's not really it. Fuzzy boundaries, along with poor information about the existence and ownership of the property right, and inadequate incentives for parties on both sides to find each other, taken together, those are the sources of notice failure. When I say notice failure, what I mean is that there is a bargaining failure because parties cannot find each other. What works well in pharma and what works well with real property is that parties will strike an ex-ante bargain if one party wants to use assets or resources controlled by another party, or that developing party will simply avoid the assets controlled by the counterparty. Notice failure means that bargains don't happen because parties don't find each other. Again, pre-Troll, looking at the 84 to 99 period, Benton and I found that in 28% of lawsuits between operating companies, the parties on the two sides of the litigation had no industry overlap. We looked at the technology where parties were patenting, and we found often they were strangers with regard to both technology and strangers with regard to industry. We've had for a long time a core problem in our patent system that you're surprised by a patent lawsuit. It's brought by someone that you don't have any particular business relationship with. It's not a place where you'd be looking to see if there are, it's not a neighbor of mine where I'd look to see if there are property rights that I might stray over. So who's responsible? It might be the technology. So software might be different. I think the problems are more serious with software, but the evidence in the book with Benton says that it's really a problem in lots of different technologies, not just software. In that book, we focused very heavily on the fault lying with the government, bad law, bad administration. But in recent work, I've focused more on the property owner and on a concept that I call a notice externality. So the core notion is the following. For a property system to work well, the public needs to know about the existence of the property right, who owns the property right, the scope of the rights. That information is a public good. It could be provided by the government, and it is to some extent. It can be provided by private parties, and it should be. But because it's a public good, it gets underprovided. That's the source of the externality. We need property owners to stop hiding property rights, hiding ownership, and degrading boundary information, and we need to provide incentives for them to move in the opposite direction. You know that this is the way we think about the pollution problem. We think about an externality. I take an action that benefits me, but I don't pay attention to the cost it imposes on others. I think the same sort of attitude should be applied to the patent system, is that property owners, when they claim or modify their property rights, need to invest in communicating existence, scope, and ownership information to account for the harm that they would cause to third parties. Clearance costs, over-deterrence, and litigation and abandoned projects. Those are the external harms that need to be internalized. We need to stop people from acquiring too many rights, hiding ownership, and choosing fuzzy boundary information. That leads to my focus on reforms like Mark's reform, dealing directly with functional language, leads me to favor transparency so that potential counterparties can find each other. It leads me to prefer that the PTO would shift its primary focus in examination from 102 and 103 to 112. And finally, it leads me to favor significantly higher fees associated with software patents or other kinds of technology that generate external notice costs. Patent lawyers will often talk about examination as being the responsibility of the government. They say, don't make me do this. It's not my responsibility. It's the government's responsibility. That is wrong. We need to generate significant fees from patent applicants who are generating external notice costs and take those fees into an examination process that is much more intense, especially in terms of clarity of claim language, and the simpler reforms with transparency, I think, also can be achieved. So I think that's the philosophic shift in philosophy that we need to make in order to really orchestrate effective patent reform.
All right, great. Thanks, Mike. And we're going to Michael number 2, although it's definitely not the lesser Michael.
Thanks, Polk. Thank you to Penn Law for having me here. I'm pleased to be speaking and presenting here today. It's amazing how much I agree with Mike on a lot of these issues and yet disagree on what we should do, although not as much as you would think, So I want to start today with some broad discussion of software-based reform, what we should think about. But then I want to step back and talk about the bigger picture and some history. I want to situate software within history focusing in part on the automobile for reasons just because I saw this cartoon that Congressman Goodlatte put out last week, and I also just got a book about the Selden patent case, and those two things came together, and it was interesting enough. But then I want to move back to some software-specific concerns and discuss some unanswered questions about what we should be doing. So I want to start with some relatively uncontroversial assertions. I think we heard a lot of them just now. Patents can be vague, ambiguous, unclear. Patents can be invalid. Patent owners want to expand their patent breadth to get as much as they can in infringement. And doing so in litigation is very costly for everybody. When defendants have to pay unwarranted license fees, and I shouldn't say defendants because not everybody's a defendant, people pay license fees without a lawsuit, but they're unwarranted, that can be costly. At the same time, patent defendants want fees to be considered unwarranted, and few of these concerns can be solved at the time of patenting. That, I think, is really the big issue. The question is, can we solve these with examination? A lot of the questions about claim scope and breadth don't come up until 15 years later when we see what's finally happening out there and somebody makes a claim that the patent was broader than it really was. So that leads to the software question. Is there something about software that requires technology-specific reform? And I think we can disassemble that question. That's software patent nerd humor, for those of you who get it. Into, do we solve this at the time of litigation? And if so, how? Do we solve the problems before litigation? Do we do it piecemeal, a patent at a time? Do we do it wholesale, as the free software folks would say, just get rid of software patents altogether? Do we attempt to solve the problems at all? Do we think there is a problem that is somehow different? I don't know the answers to these, but I think you have to look at software as part of the bigger picture to consider what to do. And so that's what I want to do for just a minute here. So first, let's look at the rate of patenting. It's true that we have a lot more patents today, but until just the last couple of years, you can see from the chart, this is patenting per capita from 1790. Until just recently, our patenting per capita was within historical norms. We had a lull. Part of what we're seeing is growth in patenting beginning in the 1990s. It seems shockingly high, but only because it was low for a long period of time. Now, as we know, the amount of litigation you have runs lockstep with the amount of patents you have. And so let's look at the rate of litigation. Here we have from 1790 to 1990. Patent litigation rates are within historical norms. Yes, there are a lot of cases going on right now. There are also a lot of patents. So it is true, if we have fewer patents, we will have fewer cases. The question is whether or not that's a good thing, and I'm not sure that question has been answered. I think a lot of people think, well, all the patents now are bad and invalid, and therefore they should be. So let's look at historical win rates. This is a paper by Henry and Turner. I suggest if you're interested in the history of patenting and patent litigation, you take a look at this. It only had like 45 downloads on SSRN, so not many people are looking at it. They look at historical wins due to non-infringement and historical wins due to invalidity, and then they put it together and they model the whole thing, and they actually tie their model to actuals. That's what the chart on the right shows. What they show is what you might expect, which is in the 1940s, when we had a severe cutback in patenting, they call this the flash of genius era, we had a significant drop in win rates. And then in the 1980s, we had a significant bump in win rates right when the Federal Circuit was created. And now win rates are back into historical averages since 1930. So the question is, if all of the litigation is invalid, that's only because we're comparing it to what happened in the 80s, not because we're comparing it to what happened since the 1930s. This leads to one other point about what's new and disruptive, and part of the title of this was Disruptive Technologies. This is a chart of overall litigation. This is not just patent litigation, it's overall litigation of different technologies right around the time those technologies grew. You can see when the telegraph came, there was a spike in litigation. When telephones came, there was a spike in litigation. When the automobile comes, there is a spike in litigation. Is it any surprise that when we have a disruptive technology like software, that litigation will spike? So the question is, will it decrease? Probably. Will it decrease due to some reform efforts where we try and recalibrate exactly what we're going to do? Probably. And that's part of what we're struggling with here. I want to focus in more detail about automobiles, because we saw from the Goodlatte cartoon how poor Henry Ford was sued by this patent troll. There's the graphic right there, right out of the YouTube video. Except the problem was that it was Ford's competitors who bought the patent, and it was competitors who were suing Ford. It wasn't a patent troll. It was a practicing entity. Now the question is, does this make the Selden patent any better? No, of course not. If the patent was invalid, the patent was invalid. But it means that our policy should be based on fact and not folklore. And so I'll give you a couple of other examples. These come from the William Greenleaf book, Monopoly on Wheels, from 1961, before any patent troll debate, although it's been reissued in 2011. You can get it in paperback pretty cheaply. So one was, people say there was investment shackling. Investment was cut down because of this Selden case. And Greenleaf says there's no evidence of that. That's not what happened. Greenleaf says that the things required to make automobiles go were within the possession of the automobile companies already. And this paragraph struck a chord with me when I read it, because it sounds a lot like software today. Yes, maybe there is a tax on the system. Let's take that as a given. There is a tax on the system. The question is, if innovation is getting slowed down, it would be awfully scary to what it would look like unbridled. And the other comment I have on that is, look at how old some of these inventions are that are being asserted today. I actually think that that's a problem, because I think what's happening, and this ties to the functional claiming, where people are claiming a function, people are inventing on specific equipment, and they never foresaw that the patents would be broader. But if it's true that nobody knew about these patents, why didn't all of these inventions come earlier? All of this great software we have now, why didn't it come earlier? The answer is the hardware just wasn't there yet. The hardware just wasn't there yet, and so the reality is software is going to grow as the technology, the bandwidth, which of course comes from research and development that people spend money on to create patents, etc. But the idea is that the pace of innovation will go forward at its own pace. So one more point on the automobile litigation, and that is all of the other litigation that went on. This is a longer quote, but the gist is, if you read this paragraph, it reads much like what we see today. There were lots and lots of people with lots of patents in the automobile area on all sorts of little gizmos and accessories and attachments, and you couldn't build a car without being sued on somebody who had a car horn patent, or a bumper patent, or a mirror patent. By 1910, the courts were crowded with cases, many of them brought by freebooters who trafficked in disputed inventions. Sound familiar? They worked it out, though. They worked it out. How did the automobile industry work it out? First of all, they changed litigation procedure. The Selden case took 5 years to try, if you can believe that, because of the way they took testimony. After that case, they changed the way they took testimony, and people say it should have taken 60 days now. Maybe some of the changes that are coming now will help move litigation faster. And we should consider those, but we should consider them while also allowing people to assert their rights. They created patent pools, but interestingly, the initial patent pools included smaller players. They included smaller players and people who didn't even make anything until the large manufacturers got very mad. They didn't like the smaller players getting paid. This too sounds familiar. However, Ford never joined any of these and went alone and kept getting sued and negotiated and used whatever leverage was there as the large manufacturer. I'm running out of time, so I want to move to some software-specific things. A couple of them. One, to this fuzzy boundaries point. This is a couple of charts. One is from Anderson and Manel, one is from Miller, on reversals. Now, this is the Federal Circuit reversing district courts. The interesting thing is, it's unclear to me whether that means there's unclarity. But assuming that means it's unclarity, if we look since the Phillips case in about, when was that, 2006? The rate of reversal for software has dropped to 20%, for computer-related is somewhere in the 20%, and for communications is down at 20%, down from the 40s. Business methods actually went up, but it's a very small piece of the pie. Now, Miller finds that 45%, I've got a green laser here, Miller finds the error rate is 28%. This is across all the years. He hasn't done the separation. And 45% in software. But note that it's an appeal from the owner win. In other words, the reversal goes against the patentee in most of these cases. So when we're thinking about patent reform to remove deference, to give deference to district courts, we should be thinking about what that means with respect to appeal rights. Finally, and this is a big one because the conventional wisdom is that non-practicing entities like fuzzy patents so they can extract fees from people, but if you look, software is actually a much lower percentage than product firm owners, which are at 50% according to Miller. It's the product owner patents that are the ones that get reversed. Finally, I want to talk very briefly about the role of individuals. The high growth in non-practicing entity activity is software. We know from the Katropia, Kaysan, and Schwartz study, which we'll hear about in the next session, that 10% of cases and by count of defendants or so are individuals. My own study found that 30% of patents litigated by the most litigious NPEs were originally assigned to individuals. And so the question is, what do we think about individuals? Patenting among individuals is tied to the ebb and flow of large company R&D, and it can be done in the garage. It can be done in the garage. That could be why we're seeing growth in software. I've got 15 seconds. The questions we have then, which I will finish up very quickly, are individuals attempting to license? I don't know the answer to that. We don't have good studies on that. Are they forming startups post-patenting? Are they obtaining patents after their startup fails? Do we want them to have credibility of enforcement by having a mechanism to sue? Does corporate form matter? Do we treat individually owned companies the same as individuals? Do we think individuals add nothing to the patent system? Should we answer these questions before we have broad-based reform? Thank you.
Thanks very much, Mike. And next up is David Abrams.
Hi, happy to be here today. Happy to see a nice crowd of familiar and some new faces. I am on the faculty of the law school here, as well as Wharton. My background is in economics, and I don't really have too much of a dog in the software patent fight. So why am I on this panel? I think it's to talk about one of the subtitles of this conference. The conference title is Patent Reform, Theoretical Propositions and Factual Foundations. I'm hopefully here to provide some factual foundations, which I think are going to be relevant for how we think about software patents. And so that's what I'm going to give to you today. A lot of the work that I'll give you a little slice of would take much longer to present in full. Some of it you can find on my website, but I'd be really happy to talk to you all at lunch if people have questions beyond what I'm able to talk about here, because I know my colleague, Professor Wagner, is going to snatch the microphone away from me in about 14 minutes. So let's get going. So the major patent policy question of the day, besides NPEs, of course, is what to do about software patents. So what are the complaints about software patents, which we've already heard some of from Michael and Michael? Software patents do not promote, but rather they stifle innovation, not what we think patents are supposed to do. Software patents are used as weapons, like this, very dangerous weapons. Patents are unnecessary to incentivize innovation in the software industry or in industries that make use of software. That's something that we hear a lot of, and that's maybe even the biggest concern. If we don't need patents to incentivize software, then we're just creating a lot of deadweight loss by having them in this arena. So this is how I think about this from an economic perspective, and to be honest, there's nothing special about software patents. This is how I think about all patents. So if the last part especially is incorrect, there's not a great argument for software patents. If software patents aren't necessary to get this kind of innovation, what do we need them for? But, so if you kind of believe this, that we don't need software patents at all, that they don't induce any extra innovation, then you should be done and say, get rid of software patents today. If you think they do induce at least some innovation, as we generally believe patents do, which is why we have a patent system in the first place, then the question becomes, is the net social value of software patents positive? And so that's a question I think we want to figure out the answer to, and I'm going to try to shed a little light on that today. If I had 5 more minutes, I could completely answer it, but I'll get cut off.
You can have my 5. You can have my 5.
No, I couldn't. So today we're going to get started at that, not by getting at the social value, but by looking at the private value of patents in general, and then looking at software patents. And the reason why why this is important as well, private value, is because that's what matters to innovators. They don't care about the social value. They care about the private value. They care about their bottom line. So this is something that matters a ton from a policy perspective. We might also want to think about the social value. Not gonna get to it today. So So in order to think about value of patents, we first want to know what proxies do we use for value. In the past, patent count has been used, so just the number of patents in a field as a measure of the value of innovation in that area. This seems reasonable, should be probably correlated with the value. If you see more patents in nanotechnology, that might mean the value of nanotechnology is increasing. But we know a lot about patents. We know that there's vast variation in their value. A lot of them are not even worth what it costs to secure them. And so it's probably going to be a very, very crude proxy for them. So over the past 2 decades or more, the proxy that's been used more commonly than patent count is citation-weighted patent counts. And this is, you take a patent, you weight it by the number of subsequent citations, forward citations it receives by other patents, and that gives you a better proxy for its value. And the idea here, the intuition is pretty clear. If you're a very valuable patent, other patents are going to be building on your work, citing you. You'll receive more forward citations corresponding to your higher value. This is kind of the intuition and the belief that has underpinned hundreds of papers in the literature on innovation, economic growth, and patents in particular, and it's kind of the received wisdom through today. This was what I want to focus on for a bit and ask, is this actually correct? So there's a huge literature that use these proxies for value of innovation, but almost only a handful investigate the validity. Why? Given the enormous industry that uses this proxy, turns out it's really hard to get data with real measures of value. Why is that? Well, who potentially has it? Could be firms that own patents, that use their patents to produce items. Thing is, most firms that use their patents to produce products don't particularly care how much their patent's worth. They just care that they can sell their product. They just care that their R&D department is producing innovation that allows them to sell and market goods. Not that they don't care at all, but they probably don't care, they probably don't need to know in general precisely how much each patent is worth. People have tried to infer patent value in a number of different ways. Surveys, stock market value, so very indirect, trying to use stock market value to infer value of intellectual property assets of companies, patent renewal data. It's been used by Michael's frequent co-author, Jim Besson, and demand system estimation. So all are basically indirect ways to try to get information on patent value. But because of this problem I pointed out, it's hard to get actual value. But who's the perfect source of getting information on patent value? Who has the incentive to know what their patents are worth precisely? Who gets real revenue on a per patent basis sometimes? NPEs. That's their business model. At least that's the business model of some NPEs, is to try to license patents and get revenue directly from them and care about understanding what they're worth. So that's going to be the source of the data that I'll now present to you in the next couple minutes. NPEs. So a few caveats before I show this to you. There's some restrictions on what I'm able to say due to confidentiality agreements. Can't identify the data sources nor the exact level of revenues, but can say a bunch of information still, tens of thousands of patents, get patent year licensee level revenues for about the last 5 years, and almost all the data comes from licensing agreements to customers. They're usually licensed, patents usually get licensed in large portfolios, usually to multiple parties, and revenue allocation is determined by the prominence of patent in the licensing deal. There are strong financial incentives among multiple parties for getting these things right, for getting the valuation right. Okay, so that's where the data is going to come from. NPEs, it's going to include large number of patents, something that nobody's been able to look at before. Actual data on revenue tied to specific patents. This is going to let me examine this fundamental assumption that's been made in pretty much all the literature that tries to look at valuing innovation, thinking about the value of innovation. So what happens when we do this? When we look at this, and it's very simple to do, just look at the relationship between forward citations and value of patents. People have been assuming it's linear. Let me show you the figure. So this is what it looks like. Not linear, not even monotonic. So this is forward citations on the y-axis and value on the x-axis. These are not real values, I'll tell you. This has been normalized, but the relative values are correct. And what we find is there is an approximate linear relationship for relatively low valued patents, but once you get about above the median, you start seeing a declining relationship. So this is something that surprised me a lot, and I think it surprised most people who've looked at this before, who haven't seen this before. So how do we potentially explain this surprising finding? And again, I think it's super surprising that it's, I thought maybe it might be a concave function, but I did not expect this would start curving down. So I come up with a new theory that has both productive innovations, where innovation has positive spillovers leading to positive forward citations, and you have this increasing link between value and citations, but also strategic innovations where if you come up with an innovation that's worth a bunch of money, it's worth it to you to try to protect it, to invest more money to protect it so other people are not going to try to infringe on your territory. And when you do that, you actually decrease the amount of subsequent citations you receive because you effectively scare off competitors. The model predicts the inverted U, and importantly, it produces other testable implications that we didn't know about ahead of time. So if you're going to do science, you have to be able to have some out-of-sample predictions that you can test. You can't just come up with a model that explains your findings. Otherwise, it's just a story. So we do that, and effectively we verify the other predictions of the model. So we're pretty confident in that. Okay, a little bit of data, and then I want to come back to software patents. So some of the technology categories in the data we have, let's just look at internet and software patents. So we can compare these by technology category. And again, these are not real, but these are relative numbers are correct. So we can see software patents are actually kind of close to the top. They're well above the mean value for these categories. And as far as citations go, they're pretty close to the mean. Not too different. We can also see whether this pattern, this inverted U, holds within the software patent category, and it does. So this is just software patents, not all technology categories like we looked at before. You still see this inverted U. So even in software patents, we find this relationship where it looks like at some point patents become valuable enough for you to try to protect them and reduce subsequent citations. You can look at the regression form, and I've got lots more tables for those of you who are interested. It basically shows the same thing that the pictures do. We can also look at mean to median measures of revenue or value. We see that they're highly skewed, so the mean is way higher than the median. This is true for all the categories, but especially true, most true in software patents. So what does this tell us? Especially in software patents, some high-value patents, a small number of high-value patents are really pushing up the mean value, right? So we've got a lot of patents that are not worth all that much, but a smaller number that are worth a ton. We don't see that nearly as much in the citation distribution. Okay, I've got 1 minute left. I'm going to be the first to be on time and wrap up. So forward citations, the most commonly used proxy for value of innovation don't seem to quite work the way we thought it does. This goes for software patents as well as others. Software patents appear to have very high private value and also very skewed private value again, so it's partly like a lottery ticket. A small number seem to have especially high value. As I mentioned, the question about net social value still remains open. And then just to bring us back to software patents, I think this is what we need to know the answer to really get to the policy question of, are software patents, or in general, or any type of patents, good or bad? Are they a net welfare gain to society or not, having those patents? Before we know that, I don't think we can say much about software patents or any other subsets of patents. So, thanks.
Excellent. Thank you, David. All right, so our last but certainly not least speaker on the panel will be Peter Dekken, who's going to stay here and I think generally comment on some of the other presentations, and then we will probably have a good amount of time for audience Q&A. So, Peter.
Thanks, Polk. I'm happy to be here in an academic conference in a room full of academics. Let me tell you, I'm not an academic. I learned very early in my career it's a big mistake for me to pretend to be an academic. So I'm going to distinguish myself by simply sitting here, and this one's not on?
Yeah. Just move it closer.
That's better? Great.
Yeah.
Okay.
Yeah, so lean into your mics.
Okay, well, I'm still planning to stay here because I want to distinguish myself from the other academics. I have no presentation. I hope to avoid the klaxon sound here. I could have given you my 5 minutes. And mostly because also, as you've probably already seen, I tend to talk really fast, so I can hopefully finish quickly. I really only want to make 2 points. The first is to explain a little bit more about my company, because I think it's one that is not well understood, and I want to do it in the context of the title of this panel. We're here to talk about the value of software patents, and you've heard some great presentations and a lot of numbers and theory and academic theories. But the fact is that in the real world, nobody cares about the value of software patents. People care about the value of software inventions. People care about what's happening when people are inventing things. Patents are simply, let's never forget, the legal title, the legal means by which you could hold title to inventions. Just like, nobody talks about business models for deeds. You talk about business models for real estate. And yes, I know, Mark, the analogy is imperfect, but at least I think at this level it works. Nobody talks about a business model in stock certificates. You talk about a business model of investing in companies. We shouldn't be talking about the value of patents or the business models of patents. We should be talking about business models of invention. And that's what my company does. We invest in invention. We do it through ways. We buy, build, and partner. I'm going to be very brief about this. Happy to go into detail, but this isn't intended as an advertisement for my company. Just want to explain it a little bit more. We have a series of funds, a family of funds that focuses on building inventions, software, hardware, medical devices. We have a lab. We have inventors who try to solve hard problems, come up with inventions, which we then monetize. Some of them we monetize the old-fashioned way by starting a company, but frankly, we're not very good at that. We can find people who are good at that, and we will spin out to them on an exclusive basis, or we'll license, or we'll sell, or we'll do any other creative thing that will give us a return on our investment, which is all we're about. We also partner. We work with research institutions around the world on basically the same basis. We identify hard problems, and we work with research institutions that have expertise in solving those problems and say, if you help us solve this problem, we will do what we do best. We'll help secure the rights to those inventions that solve the problem, and then we'll help monetize it. We'll start companies, we'll license exclusively, non-exclusively, we'll sell. Again, any one of the main creative ways that you can think of to monetize inventions. Think of it like venture capital. It's just at a lower level. We are creating inventions. We're creating something new and then going out and monetizing it. The part of our firm that has gotten the most attention, it's the biggest part of our firm, is more like private equity. It's the buy. It's where we take inventions that already exist but are languishing in their current area, and we say, listen, we think we could do a better job at monetizing these inventions than the current owner for whatever reason, because we have more expertise, we have more resources, we have more time, whatever reason, the same reasons you've heard private equity use for years. And we will then take those inventions and we will monetize them, again, using our resource. Frankly, at the end of the day, we're nothing more than a middleman. We're taking the producers of invention, and giving them an efficient way to monetize their invention. Because right now, until we came along, they had two methods of monetizing their invention. They could license it, or they could start their own company. Well, not all inventors were good at those, either of those. Either whether you talk about the romanticized individual inventor, which is not a myth, or whether you're talking about the large corporations, this is not something they're all good at. So we would take the sources of invention, give them an efficient way to monetize their invention. We'd go to the users of invention, because every sophisticated company will tell you that they didn't invent everything in their products. A law that is much higher than anything any of you have ever studied, called Moore's Law, demands it. Moore's Law demands product integration. That's actually not what Moore's Law is, but what the natural result is. And just like Apple today sells more digital cameras than Kodak ever did, and Kodak invented the digital camera, by the way, and Apple today sells more cell phones than Motorola ever did, and Motorola invented the cell phone. But the fact is that Apple has created a product that integrates various features, and Apple will be the first, and I'm picking on Apple, but you can substitute any other company you want. Apple recognizes that they are borrowing the intellectual property from many, many sources, and they'd like an efficient means to have access to those sources. So we think we are providing an efficient means for access for companies like Apple, and an efficient means for inventors to both have access to and monetize inventions. And that's really all we're about. The second point I wanted to make, so that's getting to the point of the value of software patents. We focus on the value of software inventions. That's what we're about. The second point I wanted to make is that I'm going to disappoint Polk, because he was hoping that this is the second or third panel I've been on with Mike Meurer, and they tend to provide some heated discussion on various topics. And I think Polk was hoping for similar fireworks here. But this is the first time that usually the topic is the extent of the problem. And Mike and I have very differing views on the extent of the problem, mainly because I rely on objective government data. He relies on data provided by a company whose job is to sell patent insurance. But we could put that aside, because today Mike was more, you'll get your chance to respond. Mike was more focusing on solutions. And while we disagree on the extent of the problem, I'm the first to admit that the system could use tweaking, the system could use improvement, the system could always use improvement. And I agree with about 60 to 70% of what Mike was suggesting are potential areas to focus on improvement. So I was encouraged to see that. One area, though, I disagree with on, when perhaps we can get a discussion about this, is on the transparency issue. I've written about this, I think, not in any academic format, so you'd have to look at blogs, which are written very differently than what you folks are used to. But when it comes to, on the buy side, the need for transparency, I really don't understand the issue. People have been buying and selling property for years, wishing to hide their identity for non-nefarious purposes, mostly in our case because we don't want our competitors to know what we're up to. We do put a lot of effort into deciding what we want to invest in, and we don't feel like sharing that effort with our competitors. Now, when it comes to assertion, that's a different matter. When we do assertion, we always do it in our own name, in the name of intellectual ventures. I understand the need to have a transparency on assertion, but the notion that there's an inability for folks who want to license to find the people who hold the patents that they actually license, that's a problem, a solution looking for a problem. I don't think in the real world, I'd be interested to hear if Mike could give me 5 examples of people who wanted to take a license to a patent but were unable to identify the actual owner of the patent and the person from whom they needed to take those rights. It just doesn't happen in my experience. I think that there are some other comments I can make based on my experience in the real world in response to some of the other things that were presented here, but I'm not sure if that's an area that folks really want to hear about, so I'm going to end on that note.
Great, thanks, Peter. All right, so we have about a little more than 15 minutes left of this panel. So what I think we'll do first is let the other panelists, if you want to comment briefly, we'll spend the first couple minutes on this, on anything you heard from one of the other presentations, and then we will throw it open more broadly. So I'm sure Mike has something to say. So make sure you lean into your mic.
I'm not going to be too combative because Mike and Peter are both kind, and so I'll try to reciprocate. Peter's last comment is actually a very interesting comment, and I'm working on a paper now on transparency, and the argument that Intellectual Ventures made back in January in the comment to the PTO, it's an interesting comment. The comment you just made right now about the buy side. Peter, if he had more time, I guess he would compare this to dealing with holdout problems in land, possible benefits of secrecy in that context. That's what you're thinking, right?
The classic example is Disney buying land in Florida.
Yeah. So I recognize that as an interesting argument. I'm thinking about that, and I see merit to your position. I don't know if I agree that we should preserve that anonymity. But anyway, I'm currently thinking about whether or not that's desirable. The reason it might not be desirable from my point of view is that when I'm a research manager and I'm looking at a strategy that involves devoting resources to a particular area, I'd like to see as much detail as I can about ownership of patents. And I might see some owners I think are more litigious than others, and I might steer clear of that. So even well before we get to assertion, I'd like maybe more transparency, but I hear what you're saying. I'll think more about that. In terms of Michael's comments about history and that today is no different from the past, I think the episodes you talked about in the past were pretty bad. So I think you're right, is that we're not really so different from the 1870s and 80s, and we don't have good data on what the patent system was doing at that point in time. But I suspect that if we got good data in the 1870s and 1880s, we'd see that the patent system was imposing a net tax. So I'm kind of unhappy to see history repeating itself. And as Michael knows, I'm not particularly out to get the trolls. I don't particularly see them as a problem. That's why Michael and I guess, agree on a lot of this. But one thing I want to add to Michael's analysis about the frequency of patent litigation is that if you take litigation and divide not by patents, but litigation and divide by R&D spending, over the period where I have the data, that number is going up. And I think that's the better denominator. Amount being spent on R&D is the right denominator, not number of patents, because number of patents can change over time. I might approach an invention and decide I'm going to get 10 patents on this invention or 3 patents. Practices like that have changed over time. And at any rate, patents aren't really what we care about. It's spending on R&D. That's not quite it either. It's inventions that we care about. But I think spending on R&D is more closely correlated with invention than patent counts are correlated with invention. So I would shift the focus to that. Thanks.
All right. Anyone else want to brief? No? Everybody good?
The one thing I'd add, I've never seen much use for the transparency. I know everybody else likes it, but I've never seen much use for the transparency point, even in assertion, except for the assertion where you have multiple companies purporting to be the owner or exclusive licensee for an area. I think their transparency is extra important because you wind up with overlapping claims. And in fact, historically, you look at that being a real problem with licensing agents. So I think that's an area, and maybe that's a key area to focus on. But the rest, I don't have anything particular.
Okay. Real quick.
I just have, very quickly, and we don't have to talk about this now. These are more small questions for each of you, one for Mike Meurer. You talk about a large fraction of litigation among unrelated companies. That was the empirical slide that caught my eye, not surprisingly. But shouldn't we want or expect that to be the case? Because if companies are playing well together and know each other, they're probably less likely to sue each other.
Yeah, super fast. It never happens with pharma.
But
So it doesn't happen with pharma.
It never happens with pharma.
Yeah.
Where we've got good notice, disputes arise in pharma, but they're disputes between people that know each other. There's some bargaining breakdown for some other reason. It's not notice failure, though. These are parties that could have negotiated in advance. And we know that even when you find your counterparty, sometimes you have a breakdown of negotiation, sometimes you have litigation.
Okay. I have other questions, but I think this is getting a little bit
The weeds.
Yeah, into the weeds. And for other Michael, about patenting by individuals, I think that's a great question, individuals versus corporations. I'll just say one thing, which I didn't put in the slides. I have some new data that indicates that patents by individuals tend to be substantially less valuable than that done by corporations. So that's another piece of evidence. It's not the only thing that we care about, I think. There might be some spillovers as well. There might be other things that we want to incentivize, but that's something I think we didn't really know very well, and I think that some of the new data shed some light on that.
That's helpful.
Great. All right, so we're gonna do a little broader Q&A here, and I'm gonna take the moderator's prerogative to throw out the first question. One of the themes that we've tried to follow in putting together this conference is to try and bring as many facts and data as possible to the issue of patent reform, because so much of patent reform seems to have this two ships passing in the night sort of quality, where people can generally agree on lots of things, but not actually agree on any actual solutions or what might happen. And so I wanted to ask the panel, and this is for everybody. We heard a lot of sort of problems identified, things like fuzzy boundaries, lack of notice, uncertainty, those sorts of things. What data, what information, what work should we be doing as researchers and scholars and policymakers to try and actually bring factual information to some of those things? I mean, how do we know if a patent has fuzzy boundaries or not? How do we know whether the uncertainty surrounding software, for example, is greater than the uncertainty surrounding integrated circuit patents? Those are the sorts of things I think which have the potential to really push the debate forward rather than keeping us mired in just talking about the same things over and over.
I have two comments. The FTC is looking to do their civil investigation to generate some data. So if they can generate interesting data, and if it's not too severely anonymized so that researchers have access to it, that's really great. You know, what David was talking about, he's got this treasure of data on licensing, and no one else has anything like that. So maybe the FTC will produce data of comparable or better quality. Second, with regard to empirically implementing tests having to do with functional claiming or fuzzy boundaries, it's hard. I pointed to Hemphill and Sampot, and Colleen Chen is trying to do something. And in both cases, it involves looking to the claim language and using words in the claim language as proxies. And that may not be great, but that's a start, and a few people have started to do that. You know, you could do simple things like look for Jepson claims, or Dennis Crouch all the time does these great little stories about how often does substantially appear in a patent claim. You know, and he'll give you a little table showing how it's declined over time, or 112F, how often is that being used? So I think that's the route to go for further empirical investigation.
I think it's tough on the unclarity. The problem is, of course, that once parties get into litigation, everything's unclear. So I think you have to design some sort, if you're not going to do it with automated, like how often does substantially show up, you have to have some sort of survey where you have people with skill reading patents and grading them somehow. And it's tough. I'm launching a study on continuations where I'm going to have engineers reading patents and have them comment on breadth and written description depending on whether it's the continuation or the original, to see whether amendments change the nature of claims, make them more unclear. Hopefully we'll get some good data from that. As for the two ships passing in the night, finding different two ships, but finding each other because they can't find their neighbors. I think even qualitative case studies will be helpful, but it's really, really hard because the big patents that are being litigated, you ask the individuals, can you tell us what you did and to try and license this before it was sold off to somebody who started suing people, and you basically get no answer. It's like, we're in litigation, sorry, I can't tell you anything. And you have to rely on NPR to go do a story, and that's the only way you can find out what happened.
Sure, you had to bring that up.
And that's bad news. So I think you've got to have more qualitative stories, which means that people who are patent owners and asserting patents have to be willing to talk about it, even though they're in litigation. And I think that's the only way to get more factual data, even though it's more like survey, qualitative, interviewish.
Just briefly, I agree with both suggestions from Mike and Michael, and we'll add one more, which is also a little advertisement for our next conference or one of our forthcoming conferences in the spring. Natural language processing, that's another way that Polk and I, among others, have talked about in an automated way. And I think it's a good complement to what you're talking about, Michael, getting experts to read through the patents. But we're talking about starting with that to train algorithms to recognize what is a fuzzy patent, and maybe then be able to do it en masse in a way you couldn't just by having people read them.
So once again, I'm happy to be able to bring the real-world experience to an academic panel. The rest of my background, by the way, I'm vice chairman of IV, not a vice president. Before that, I was the head of patents, licensing, and litigation at Intel, and before that, I was a partner at Wilson Sonsini, a Silicon Valley law firm. So as a result of my career, I've now managed two of the world's largest patent portfolios and counseled numerous small companies. I've read a lot of patents, folks. I don't know about any of these studies, but I've looked at a lot of patents, and Polk actually used the right example. The comparison is not, as Mike Meurer would have you believe, between farmer patents on the one hand and software patents on the other. Yes, software patents are much more fuzzy on their boundaries than farmer patents, which are very, very clean and precise and narrowly drawn. But I think a better example, in my experience, is between software, which is a new and fairly relatively unsophisticated field, versus integrated circuits. I've read a lot about integrated circuit and semiconductor patents, both on the process side and on the design side. And I can tell you that the challenges of interpretation are the same in both cases. In neither case are the boundaries clear. In both cases, they're fuzzy. Why? Because you're using the English language to try to describe something that by definition never existed before. This is not easy, and it's an imperfect job left to imperfect patent lawyers dealing with imperfect patent examiners. You're going to end up with fuzzy boundaries. I agree they are fuzzy, and I think only by better training on all sides will they get a little clearer, but they're no more fuzzy today than they ever have been in the past.
Okay, so with that, we have a few minutes left, so raise your hand, and if you're going to ask a question, be sure to lean into a mic and speak clearly and loudly. So, up here.
I want to comment on this patent citation.
So if you could introduce yourself before as you do it. So.
My name is Steve Mendelson. I'm a patent prosecutor here in Philadelphia. I want to comment on this patent citation analysis. To me, it's lazy person's patent law. The number of times a case gets cited in other patents is a function of the quality of the specification, not the quality of the claims. When we file information disclosure statements, we don't even look at the claims because we're trying to get a patent for our client. And the relevancy of those citations, whether they're patents or articles or whatever, is the disclosure in them, not what they cover. So we don't care what the claims look like when we're determining whether to cite a patent in our patent application as a prior art reference. And this whole idea of just looking at numbers without looking at the scope of the claims is just, to me, it's just lazy. And it doesn't end up with accurate results, which is what your data is finally showing.
Not only that, but my experience was that people often cited patents to say what didn't work in the past, which is the counter to the point of value.
Peter, can you repeat that?
I was saying that people often cited patents in future patents as a way to say, here's an approach that never worked, here's an approach that didn't work. That would count as a forward citation, even though it's counter to the point of value.
Just like law review articles.
Yep. So your comment is one I've heard before numerous times from actual patent prosecutors, and I think it's well taken, and I think it's supported, it's reflected in the data. That being said, if you have to think about if you want to think about in a quantitative way innovation policy. I mean, if you're trying to think about how do we get GDP growth above 2%, 3%, and we think innovation policy is one lever we've got, we want to know how much innovation is worth. We have to measure that. It's very hard to measure, and so people have to come up with some proxies. They can't read every patent by themselves. There are a lot of them, you know that. And so that's what's been used. That's why people have used first simple patent counts and then citation-weighted patent counts, and they're not great. And so I'm hoping this is going to lead us to the next iteration that gets us closer to real value and saying forward citations are not the answer by themselves for the reasons you mentioned, Peter mentioned, I think others people can think of, but maybe there are additional characteristics of patents that we can use in an automated and crude way to predict the overall value when we need to do it in a massive way. And that's the next step in my research project, is looking at other characteristics of patents.
Okay. Other? John?
Yeah, hi, John Ferris. I'm a patent litigator, and I'd like to comment on Mike Meurer's discussion of pharmaceutical patents. Peter said, I have for decades now litigated pharmaceutical cases, big company versus big company, or big company versus generics. And with the rare exception, there's nothing clear about those claims, especially you showed a organic chemical structure up on the screen. When you look at patents in the real world that have those organic structures, around the periphery are R groups, R1, R2, R3, Z1, Z2, Z3, and then you read the body of the claim, and there are hundreds, if not thousands, of substitutions. So the claim will be drafted as this general structure where R1 could be, and then it lists a laundry list of things, where R2 could be, and it lists a laundry list of things. And if you actually did a recombination of all those pieces onto the organic structure, you have thousands. I'm actually involved in a case right now where we actually have 10 to the 40 possible compounds from the drafted claim language. And when you look at that, there is absolutely nothing clear about that. And then when you add on top of that, that you can apply the doctrinal equivalence to these claims, where is the clarity?
Nice comments. Many responses. Response number one, there's a selection process here. So it is, of course, what Michael was saying a little while ago, it's the most difficult claims that get litigated. Response number two, we know the practice in pharmaceutical industry is to read the patents, do some research, read the patents, do some more research, get something, patent, read the patents. You see resources devoted to people reading patents in the pharmaceutical industry because they make sense. They understand, by and large, what the disclosure is, by and large, what the claims are. Certainly, those cases that get litigated are the ones that are problematic. But the behavior shows that people are treating pharmaceutical patents like property. They find it as valuable to read them. And as I said before, if anyone can tell me about an important active ingredient claim that was infringed and then litigated outside of inequitable conduct or something like that, I'd love to see it. I don't think people accidentally stray across the boundaries of an active ingredient claim. Again, evidence that claims are communicating clearly to the world, this is my property, stay out of it. Negotiate with me in advance if you want to get there. And as I was saying before, you don't see someone from the semiconductor industry suing a pharma company. You don't see surprises where strangers, you know who your neighbors are. You're doing your corporate intelligence, and you're looking to see who's likely to sue me in the future, who might I work with. And finally, this hasn't been emphasized at all, but one thing we want to look for is not ex ante transactions involving patent rights. Well, Peter was talking about this, but I want to emphasize it more strongly. What we want to see is ex ante transactions involving technology. And you see that all the time in pharma and chem. Transactions involving technology where there's an early inventor who hands the technology, not just the patent rights, but the technology. And in high tech, you hardly ever see that.
Okay, so we are at the end of our time for this panel, actually a couple minutes over. We've got a 15-minute break. We're going to come back at around 10:45. I want to thank my fellow panelists for what was an outstanding panel, and hopefully we can talk a little bit in the hallway and out having some coffee, and we'll see you back here in 15 minutes.